Good evening, everyone. I'm Michael Steele. We begin this hour with a case that has enormous implications for free speech in our country. Late today, an immigration judge ruled that the Trump administration can deport Columbia University graduate student Mahmoud Khalil. The ruling comes just a month after Khalil's arrest marked the start of the federal government's broader crackdown on foreign students. Khalil has until April 23rd to file for relief. After the judge ruled, Khalil addressed the court saying, quote, "I would like to quote what you said last time, that there's nothing that's more important to this court than due process rights and fundamental fairness. Clearly, what we witnessed today, neither of these principles were present today or in this whole process. This is exactly why the Trump administration has sent me to this court, 1,000 miles away from my family. I just hope that the urgency that you deemed fit for me are afforded to the hundreds of others who have been here without hearing for months." Joining me now is Ramzi Qasim, attorney for Mahmoud Khalil. I don't even know where to begin. I am so put off by what the court decided today. Because it goes against the grain of everything that we thought we believed in as a nation. That individuals would be afforded due process, that they would not be hammered into submission by our legal or judicial system. Mr. Qasim, how do you see the events of today and the next steps in front of you leading up to April 23rd? What's your strategy going into making sure that the court realizes the importance of its own, the law regarding due process?
Thank you so much, Michael. The events of today were unfortunately all too foreseeable. When the government picks up a U.S. permanent resident, abducts a U.S. permanent resident off the streets of a U.S. citizen, rips him away from his family, from his expecting U.S. citizen wife who's about to give birth this month, takes him in the dead of night to a prison 1,500 miles away, where it can then subject him to basically a sham process in front of an immigration judge who is essentially an employee who serves at the pleasure of the president and is subject to significant political pressure. It shouldn't shock anybody that what we have is this rubber stamp decision where the Secretary of State went into that immigration court saying, literally with a 2-page memo saying this person, because of their speech, somehow poses some foreign policy concerns to the U.S. government. And therefore, at my say-so, the Secretary of State, this person should be removable. For a country that values free speech, that values due process, that considers itself an open and democratic society, that should just not be possible. And so we expected this outcome. This is exactly the government's strategy, is to accelerate and move forward as quickly as possible in the administrative court, in the immigration court of its choosing that it controls, and to isolate or to try to isolate Mahmoud, and to hope that the media attention dies away, that the popular outrage dies away. Unfortunately, it's backfiring for them. And we intend to continue to fight. Mahmoud will not only pursue his options, limited as they are in immigration court, but we were in federal court right after the hearing concluded in immigration court to update the federal judge who's hearing Mahmoud's habeas corpus petition to set him free. And we intend to pursue that option in federal court as quickly as possible to try to get him released and try to get him back to his family in New York City.
On that piece about the two-track approach, you've got the immigration courts, which which is the current purview over this case. Talk a little bit more about the second strategy on the habeas corpus argument before the federal courts. And will you find yourself in a position where the federal court will say, of all the administrative remedies been run with the immigration court system, or can you move both while you're working towards April 23rd?
Well, Michael, I mean, our contention is very simple. This is a case where Mahmoud is being punished for exercising his constitutional rights, his First Amendment rights to speak up in defense of Palestinian lives and Palestinian human rights. Nobody should be punished for that. Everybody should, in fact, applaud that. But even if you happen to disagree with his viewpoint, you should still be shocked by the fact that the Trump administration is claiming to be able to put somebody in ICE detention simply because they disagree with what he has to say. Because that template, that blueprint is one that they can apply not just to punish folks who happen to be pro-Palestinian and outspoken the way Mr. Khalil is. They can use that to punish somebody who's pro-racial justice, pro-LGBTQ rights, pro-reproductive rights, any number of issues that they happen to disagree with. So it's a really dangerous blueprint. It undermines the First Amendment, and that's our claim. Our claim is that this is a First Amendment violation. It is a due process violation, and these are not constitutional issues that can be heard before an immigration court. And so we intend to press forward in federal court. The government, of course, has a strategy where they want to slow down as much as possible and delay as much as possible the federal court case and speed up as much as possible the immigration court case, because that is the court they control, where the judges literally serve at the pleasure of the president and can be fired. In fact, today, nearly half the judges on the Board of Immigration Appeals were fired by President Trump, all the Biden appointees. So that tells you something about how reliable the Board of Immigration Appeals is and the immigration court system is. It is not a court system. It's really an administrative system, and it is subject to the control of the executive branch.